The application that we're dealing with actually doesn't deal with the elections at all. The application that we're dealing with is the very first one that was filed after the purported recalls were done. So as you know, this appeal was noted close to the end of last year. It was struck off the roll on a procedural issue, meaning that it was not heard on the merits. Unfortunately, today again, it was not heard on the merits. There was an issue raised by respondents' counsel relating to security for costs. They were insisting that they need to be tendered with security for costs before the appeal can be heard. The court has agreed with this position, meaning that the matter was removed from the roll. So that's why we're out of court quite early. It means that we still have not yet been heard on the merits. The appeal has not been dismissed. That means that we now still have to then sort out the issue of security for costs and then come back to the court for an appeal on the merits. The appeal, of course, was opposed by the respondents, so that would still be another fight yet to come. So it's simply another delay in the final hearing of the appeal on its merits.
Very short exercise. The papers were not properly before the court again. In this instance, the security, of course, was not paid, and therefore the court could not hear the matter. It was deemed abandoned. So it started, it ended there.
Just explain to us what are the security costs and what was the background?
In terms of the rules of the court, particularly the Supreme Court that we are talking about here, if you file a notice of appeal, you then tender costs for that particular application, and that must be done within 30 days. In this particular instance, it was not done, and therefore the rules of the court were violated, and hence the court could not hear that based on that.
So what's the position now?
Well, they have to reinstate that application, and then we'll take it up from there. If they intend to proceed with it, they'll have to reinstate it, unfortunately. Well, it is unfortunate, but at times it is what it is. We have to deal with it. We are the ones that are being arraigned before the court. We don't have any choice. But the good part of it is that costs have been said to be paid. So it's an application that was dismissed and that they have to pay the costs.
what this application seeks is a declarator, which is a declaration of rights. What these MPs are saying that we never cease to be members of our political party, and this person did not have authority to recall us, meaning that question alone is a live dispute. But like you said, that is an issue for debate in the main appeal, because the respondents are arguing that, well, it's all done and said through those first elections. But then what it also doesn't consider is that there's two classes of MPs that were affected by these. It's not only first past the post, there were some who are party list candidates. So their status as members or non-members of the political party still remains irrelevant. So that would again be an argument to be made before the court. It's not a fixed position.